Vermont has a tenant-protective late fee framework consistent with the state's overall strong tenant rights orientation. The governing law is found in Vermont's Landlord Tenant Statutes, Vermont Statutes Title 9, Chapter 137, along with the Vermont Consumer Protection Act and General Contract Principles. If you're a landlord or tenant in Vermont, the state's approach limits what landlords can charge and provides tenants with meaningful protections against excessive fees. Let's start with the key rule. Vermont requires that late fees be reasonable. While Vermont does not impose a specific statutory dollar cap or percentage cap, the state's consumer protection framework, including the Consumer Protection Act found in Title 9, Chapter 63, provides a basis for challenging fees that are excessive, unfair, or disproportionate to the landlord's actual damages. Vermont courts evaluate late fees under the same reasonableness standard that applies to other contractual penalty provisions. What's reasonable in Vermont? The standard is that the fee must bear a reasonable relationship to the landlord's actual damages from the late payment, administrative costs, additional accounting, follow-up communication, the time value of money, and any bank fees or other direct expenses. A fee that significantly exceeds these costs functions as a penalty rather than a reasonable pre-estimate of damages, and Vermont courts will not enforce penalty clauses. Industry standards in Vermont suggest that a flat fee of $25 to $50 or a percentage-based fee of 5 to 8% of the monthly rent is generally defensible. Vermont's Consumer Protection Act gives tenants the ability to challenge fees that exceed these ranges, and the Act provides for attorney's fees and potentially punitive relief, which creates real risk for landlords who overcharge. Vermont requires a grace period before a late fee can be charged. Under Vermont law, the landlord must provide a reasonable grace period. The standard expectation is that the tenant receives at least a few days after the due date before the fee kicks in. Most Vermont landlords provide a grace period of 5 to 7 days. While the exact number of days isn't specified with the precision found in states like Virginia, the expectation of a reasonable grace period is well established. The lease must clearly state the late fee terms, the fee amount or formula, the grace period, and the conditions for imposing the fee must be documented in the rental agreement. A late fee that isn't specified in the lease is not enforceable. Vermont courts require clear written agreement. Oral understandings about late fees are insufficient. Vermont's Consumer Protection Act adds meaningful enforcement power. Under Title 9, Section 2461, consumers, including residential tenants, can bring private actions for unfair or deceptive practices. A late fee that is excessive or that isn't disclosed in the lease can constitute an unfair practice. The tenant can recover actual damages, and the court can award attorney's fees and costs. In egregious cases, the court can award exemplary damages up to 3 times the actual damages. This means a Vermont landlord who charges a $100 late fee when their actual costs are $20 faces more than just losing the fee. They face potential treble damages plus attorney's fees. The risk-reward calculation strongly favors setting a modest, defensible fee. Compounding late fees in Vermont must satisfy the reasonableness standard. A one-time fee after the grace period is straightforward and easily defensible. A daily or weekly compounding structure that could accumulate to a significant portion of the monthly rent is much harder to defend as reasonable. Most Vermont landlords avoid compounding entirely. A single fee per late payment is the safest approach. The interaction between late fees and the eviction process in Vermont follows the state's general landlord-tenant framework. Under Vermont law, the landlord must provide proper notice before pursuing eviction for non-payment. The amount demanded in the notice must be accurate, including only legally compliant late fees. If the lease defines late fees as additional rent, they can be included in the total amount on the notice. If not, the landlord may need to pursue the fees separately. Vermont's eviction process is lengthy and tenant protective, which makes getting the numbers right essential. An overinflated demand that includes excessive late fees gives the tenant grounds to challenge the notice and delay the proceedings. Clean, compliant calculations prevent this problem. Vermont enacted rent stabilization in Burlington, a CPI-based rent cap, which may affect late fee dynamics in the state's largest rental market. While the rent stabilization ordinance primarily addresses rent increases rather than late fees, the overall regulatory environment in Burlington signals that landlord fee practices are subject to heightened scrutiny. Burlington landlords should ensure their late fee provisions are clearly reasonable. Vermont's anti-retaliation provision under Title IX, Section 4465, creates a 90-day rebuttable presumption of retaliation if the landlord takes adverse action after a tenant exercises a legal right. This is relevant to late fees in an indirect way. If a tenant complains about habitability or contacts code enforcement, and the landlord begins aggressively enforcing late fees for the first time shortly after the complaint, the tenant can argue that the sudden enforcement is retaliatory. Consistent enforcement from day one prevents this argument. For tenants receiving Housing Choice Voucher assistance, Vermont landlords should not charge late fees when the Housing Authority's portion is delayed. Vermont's overall tenant protective framework and the state's active advocacy organizations mean that penalizing voucher tenants for the authority's processing delays will likely generate complaints. Vermont limits the security deposit to 1 month's rent for tenancies of 2 years or less. When a tenant vacates with unpaid late fees, the landlord can deduct compliant fees from the deposit, but must provide an itemized statement within 14 days of the tenant vacating. Deducting excessive late fees from an already limited deposit compounds the violation. From a practical standpoint, Vermont's rental market is small but tight, particularly in Burlington and the Champlain Valley. Burlington has the tightest rental market in the state, driven by the University of Vermont, UVM Medical Center, Champlain College, and strong quality of life appeal. Burlington's low vacancy rate means that most landlords have reliable tenants who pay on time. Late fee enforcement is less of an issue in Burlington than in softer markets, but the fee must comply with reasonableness standards and the rent stabilization environment. South Burlington, Winooski, Essex, and Colchester share Burlington's tight market dynamics. Late payment rates in the Burlington metro are relatively low. Montpelier, the state capital, has a small, stable market. Late payment is uncommon among the government-employed tenant base. Rutland, Barrie, St. Johnsbury, and Bennington have more affordable markets where some tenants live on fixed or limited incomes. Social Security, disability payments, and other benefits may arrive on dates that don't align with the first of the month. Some Vermont landlords in these communities adjust rent due dates to accommodate common payment schedules, which reduces late payments and fee disputes. Brattleboro and southern Vermont communities have markets influenced by proximity to Massachusetts. Middlebury, home to Middlebury College, has a college-influenced market where student late payments typically follow the financial aid cycle. Vermont's ski resort communities, Stowe, Killington, Sugarbush, Stratton, have seasonal workforce dynamics. Seasonal workers may have irregular income patterns that affect payment timing. Some resort area landlords use weekly or bi-weekly rent structures for seasonal tenants, which changes the late fee calculation. One best practice for Vermont landlords: set your late fee at a level you can defend as reasonable, based on your actual documented costs. If your administrative cost for a late payment is $30, including your time, any bank fees, and postage for a late notice, a $35 or $40 fee is easily defensible. A $100 fee on the same $30 of actual cost invites a consumer protection challenge. Another best practice Include a grace period of at least 5 days in your lease. Vermont's expectation of reasonableness effectively requires a grace period, and 5 days is the most common standard. Document it clearly in the lease so there's no ambiguity. A third best practice: apply your late fee policy consistently and document every instance. Selective enforcement creates fair housing risk and undermines your ability to enforce against any tenant. Keep records of every late payment, every grace period calculation, and every fee charged across all tenants, all units, all months. For the complete guide to Vermont late fee laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our late fee law series.